right, so back to the House Judiciary Committee. It's Wednesday morning, May 13th. And so we had to walk through, Eric, of sections 5 on.
Okay.
So if we could hear about the changes, which I actually mentioned to folks in here already. We already have an issue on page 2, but we can get to that in a bit.
Okay,
that's fine. Walk us through the thoughts. Yes, so. Over to you.
Yes, thank you. Good morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel here to, and actually, is everyone on draft, sorry, sort of getting ahead of myself, the most recent amendment of S-193 activating to establishing a forensic facility. Does everyone have 5.1?
5.2. 5.2 we have.
All right, sounds good, which I have as well, but I noticed in House Corrections, they still had 5.1. So just want to make sure that we have the same one with you guys. So does that mean that the legislative intent language has not yet been looked at? Or
We did look at that, so you can skip that part.
Oh, okay, gotcha. All right. So not dealing with the legislative intent language at the moment would bring us right to the competency restoration services language. So in other words, remember, it can be going to this forensic facility either as a result of being found not competent to stand trial or not guilty by reason of insanity. This section right here deals with the not competent folks. And over on page 2, you see a couple of changes. So the way the proposal is now, you'll see that so this is the 4 criteria that gets the person into the forensic facility, right? And so the no changes to 1 and 4. So number 4, that you have to be found incompetent under this avenue. So you're not competent to stand trial. That's number 4. Number 1, charged with a life max sentence. So remember, there's about a dozen of those sentences that we have in Vermont, roughly, with a lifetime max. Have to have been charged with one of those. And the proposal now, the way it had been, is you could either be held without bail, or if you're not held without bail, you could be released under DOC supervision as long as you had this qualifying condition that basically would cause a substantial risk of bodily injury to somebody else if you were released. So proposal is strike that piece. So in order to qualify, you'd have to be being held without bail. Which, to be honest, if you're being charged with a life offense, chances are very good you're going to be held without bail. So not necessarily everybody, but decent chances that that's going to be your status. So in order to qualify for the facility, not competent, life sentence, held without bail, and subdivision 3, you're not currently hospitalized and getting treatment through an order of hospitalization. The proposal, I think you've seen this several times before, it's just still here to sort of highlight that it's an issue, I think, as I was told when I was walking through the same stuff in House Correction just a short while ago. This is still sort of an ongoing point of discussion, which is whether or not, in the same way that people are excluded if they're getting treatment on a hospitalization order, should you also exclude people who are subject to a commitment order to Dale, and that's the I-248 people, the people who are being held at Dale as a result of an intellectual disability. That's basically the issue there.
Right, and I don't think that that's, correct me if I'm wrong, but I don't think that that's ultimately corrections and institutions' decision on that. Or is that?
I think the bill is the bill's still in this committee, right?
Right.
I think everything ultimately stops here, so
We do what we want.
Yep.
We can't. I'm not go over it.
Nice point. So just on that issue, Eric, there's a concern that actually 2B, I mean, we may be missing somebody who, Ian raised this concern. What was the concern again? Why do we want to keep 2B in there?
Well, I think it was just, I was trying to understand why we were striking it. And if it's just about people who are in Dale custody, that's there's that exception. Why not just build that exception under 3A or 3B, and then keep the 2B language in there, because while I think you're totally right that probably a lot of the time someone who's charged with life offense would be held without bail.
Sure.
I think there are probably situations where they're held on bail they're in DOC, but they're on bail.
Yep.
Or they're, released on house arrest, or it's a different type of crime, like a felony, enhanced habitual offender enhancement case where the underlying crime is not sort of a traditional holdout, like a traditional life offense, but because they have habitual offender enhancement, it is a life offense case.
Right.
Those probably could be ones where you don't see somebody necessarily held without bail. Again, it's probably a smaller subgroup of this, and probably the majority are going to be held. But why get rid of that exception or that catch-all language?
So I think the language that we would propose is keeping 2B, and then on 3B, it would be along the lines of subject to an order of commitment to the commissioner and are currently held by DOC. So we just want to capture the individuals who may be under an order of commitment, but also are incarcerated, pre-trial or detained pre-trial. So we can think about that a little bit more, but that's, and I think that's kind of why 2B was struck. It was like, all right, it's only going to apply to people who are in prison, are in custody. Or in pre-trial, I should say. You think about that a little bit.
Okay.
Yeah.
Yeah,
That's a possibility.
right. So bottom line, we want to make sure that we're opening this avenue to anyone who's held pre-trial or not held, but with
Charged with a life offense
yeah, punishable by a life sentence,
and has the qualifying condition.
and has a qualifying condition, and then exempt from that universe folks receiving treatment and folks who are just folks who are receiving treatment, right? So is not currently. I just don't have the exemptions straight in my head, I think. I don't quite understand exactly who we're saying is not eligible. Whatever, we can move on. But I need to explain to me at some point.
Wish I could.
And I guess I would be curious to hear from state's attorneys and sheriffs if the reason that the 2B language was in there, what the situations they were thinking about.
She's
Yeah.
next door in corrections. Well, yeah,
That's right.
One after the situation I mentioned.
Yeah.
So
Because that seems to get at that, the line that's most, that I'm focused on, I guess, 7 and 8, qualifying condition that upon the person's release would create a substantial risk of bodily injury to another person. So we don't want to say that category of persons are not eligible.
Correct. Yeah.
Okay, so that's the part that I'm focused on and just trying to understand, make sure we keep all of those people in there.
Right. So we'll just need to add 3B back, but narrow it to only those who are actually held pre-trial.
Is that right?
Would it be subject to the?
Not held, not held, I'm sorry. They're not held pre-trial, they're subject to an order of commitment. I'm sorry, that's what I meant to say. Maybe that's where the confusion was. That they are not being held by DOC and they are under an order of commitment.
There's no new verbiage that I kind of like,
It's that.
commitment or something, whatever you just said, I like that.
Right in here.
Well, I'm not paying attention to that.
Oh,
Cause I'm sick
so
of beating this same dead old horse. It's like.
So
And Eric was directed to fix it, so let's get with it.
I can't.
Well, honestly, I just think.
Eric, what do you think?
Well, we already discussed that.
Are you saying that you want a person who to not be subject to this? Because these are, for subdivision 3, you're saying, all right, we're excluding people who are not currently hospitalized, right?
Right.
That's A. And you also want to exclude people who are subject to, who are committed to bail.
And are not being.
are not being detained.
Right, and not being detained.
Right.
There we go. Yeah.
Which means they're in the community,
Wait,
Maybe.
potentially.
no, but that's
Potentially.
where they
But
get
that's what you want.
treatment if they're committed to Dale.
I mean, that's what my understanding that Sherwood was trying to get at. She didn't want anybody who was committed
Right.
to Dale to be subject to this.
Right.
But my point in response to that was, well, people who have been committed to Dale, who then commit a life offense, they're often being held in DOC. They're being detained. And they're there for a while, and why shouldn't we have them go through this process if they're found incompetent to stand trial? I mean, it will lead to an exit ramp that we have in here if they're not restorable, or if they are restorable, it leads to them having their trial. So.
I mean, it starts to answer the question, like, why should anyone who is charged with a life offense not be eligible for this competency restoration structure?
Make a good point, but I think it is to get a particular committee on board.
Oh,
But have we overcomplicated it? I'm sorry, if we should, I don't want to use Eric's time, if we should be
Fair.
having this conversation at another time, because I know we might be talking in circles.
yeah.
And
Talking in circles, I think
Okay.
it's what Eric said. It's that the person is committed and is not being detained.
what,
They're out in the community. So
okay, that's more people than this, certainly.
what do you mean
Now
more
we're
people?
opening it up to some Act 248 individuals, right?
Or not, right? So presumably, in that scenario, they've gone before the court for either a hold without hearing or bail hearing, and they were determined that Dale's custody is sufficient in whatever program they have, presumably, particularly if we're talking about the hold without bail kind of hearing, because there's the safety issue that is looked at, that the court finds that it's sufficient that they're being in the custody of Dale. Presumably, that's how it ends up with somebody in that situation.
Yeah.
And yeah, should they also be subject or have, but that means they would have to be put in the forensic facility, and which may be worse than whatever programming they have.
But the programming that they have through Dale is not in any way tailored towards restoring their competency to.
Right, and I will fight this fight at another time.
Okay.
When we find out that it actually is an issue.
Yeah.
And also,
It also might not be.
It isn't, I mean, it doesn't have this specific restoration, but if it is trying to provide services, it may unintentionally be restoring people. I mean, it's not, it's, you know what I mean?
Yeah,
Like,
right.
it's more likely to do that than just having them sitting in jail waiting. There's more offered to them.
Right.
In the jail program. Yes.
I think,
I'm trying to satisfy a concern of another committee so that I.
No, I'm-
Yeah, so.
I think I'm just trying to understand.
Right.
Yeah, no,
And I guess, and I'm still wondering if we're actually leaving out a whole other, completely setting aside anyone committed to the custody of Dale. But folks who, I think, as you were saying, Ian, are charged with an offense punishable by a life sentence, or because of habitual offender, like are eligible for a life sentence.
Yes.
And are not being held, have nothing to do with Dale.
Correct.
But we just, by crossing out, by striking B, I think those are the people that we've just
Removed.
taken out of,
No, we're keeping, which B are we talking? I'm
Okay,
saying that we're keeping 2B.
okay,
This is to keep 2B is the change to 3B will address the specific concerns
Okay.
that led to this change of striking 2B. Change to 3B. Means that we can.
Because then, and then that captures this group of, because yeah, it was, the problem with striking the 2B was that it just basically removed all those people that
Yeah.
doesn't have to do with Dale or anything. And I don't know how many people that would be. My only other question was just if they are in the custody, if they are under supervision and custody of Dale before they
Right.
commit a crime. Right, so they are.
That's the scenario, yeah.
So we're saying, so what we're saying is that someone who's just in the custody of Dale, they're in the community, they're living their life for some other completely unrelated thing, but then they commit a crime that has a potential life imprisonment sentence, that they are not eligible for the forensic facility if the question of their competency is raised.
No, that's not what this would say. It would be, I mean, if they're being held,
Oh, okay.
if they're being detained, then they
They
are,
would be eligible.
they are eligible.
Okay, only if
Through the process of the hold without hearing and such, there's a determination that Dale has sufficient programming to address the safety concerns. And the court says, all right, you're not going to be detained. That's the narrow exception.
yeah.
All right, now,
That's easy.
moving on to 3A, I think, on page 3, I hope.
Yep,
Yeah.
exactly. And
You can
that's,
explain, how "and" was in fact the appropriate word and that, Tim and Dennis here was wrong.
yes, it should be and because this is talking about, well, once a person is committed to the facility, when do they get reevaluated? And they are going to get reevaluated 2 different times, at least every 6 months. And whenever the medical director says, hey, I think this person's likely competent, so we need to do a reevaluation. So it's not either or.
Perfect.
They always apply. And so it could be every 3 months, every 4 months, so it's not going to be that if you get your 6-month evaluation, then you can't get your medical director evaluation. It's both. So that's why it would be and. So subdivision 3A, page 3, this has to do with what happens if the court finds that the person is competent. So it has one of these 6-month reevaluations or whatever. Court says, all right, well, after the reevaluation, looks like the person is now competent. What do? Well, we're going back to actually the language, I think it was as it passed the Senate. They immediately notify the state's attorney and the person's counsel. So that way, the charges can be proceeded in the criminal division. The criminal case can go forward and the person can remain at the forensic facility until that criminal case gets going. So that's the idea there.
There's one.
Like that?
Yeah.
Because the language that's struck was so much more, had more to do with what's happening to the person. And we've we've gotten rid of that completely. This, the idea,
I think the idea is that the individual is continuing to be held in the forensic facility until the trial.
oh, because we say that later on,
I think.
right?
Yes, you say that they're there until their competence
Okay.
is restored or.
Yeah, thank you.
All right.
Yep, so that's what happens if the court finds that the person is competent. If they find that they're not competent, then they order continued competency treatment, and so they continue to have this every 6-month review or whenever the medical director petitions. In addition, that's sort of no changes here. We wanted to focus on the changes. That kind of where we're at, or
Yeah, just the changes that.
Yeah,
And
so-
so the discussion, I guess it's on page 8 and 9 is, I think even though really the last of the important changes.
right? And this had to do with the Dale off ramp. So we're talking about.
Yes, exactly.
Right, so you'll see that is on pages 8 and 9. And the idea here, you're at a situation, remember, this has to do with people who are not restorable. So if the court finds that the person's not restorable, the court could find, well, if they're dangerous and not restorable, then they stay at the forensic facility for treatment. It might be at the facility, might not be, but they stay in custody, are reviewed every year. If they find that they're not restorable and not dangerous, then they get released under the supervisory conditions that we have crafted earlier, and they could be under the supervision of either Dale or mental health or health, depending on what their condition is. And they could be brought back into the facility if it turns out they become dangerous again. Third option, though, is if they're not restorable, is that, well, what if they're not restorable and this is top of page 8, court finds by clear and convincing evidence the person is in need of custody, care, and rehabilitation, and that's the Act 248. That's people who are, because of intellectual disability in particular, present this danger. And so all that language from lines 4 to 13 just tracks, that basically cuts and pastes the Act 248 language. So that it has to do with the rights that the person has when they're committed to Dale. That's, if a person is committed to Dale, not through this forensic process, but through existing law, that's parallels that language, is the procedures and the rights that the person has. But they're going in through a different avenue, right? This is through the forensic facility avenue when they've been found non-restorable. So in that situation, the process you'll see added on page 8 and 9 is that, okay, well, and the definition of that person in need of custody, care, and rehabilitation includes language that there has to be an appropriate designated program available for the person. So the Dale commissioner is the one who determines that. So this provides, and the idea here is, I think this is based on testimony that you had from the commissioner, that, well, there isn't always a designated program available right away. So this allows a process for the person to continue to be held at the forensic facility until there's a designated program available, at least for a period of time. So the way the language is phrased now, starting on line 15, basically the general rule is commissioner shall provide appropriate custody, care, and rehabilitation, that's the Act 248 language again, in a designated program to the person who's committed under subdivision A. So again, the person has come in through the forensic process because the court found that they were not restorable because of an intellectual disability, and they would be appropriate for Dale custody. That's the case. Commissioner provides them with custody care, but over on top of page 9, the court may order continued treatment at the forensic facility. In other words, they may keep the person there for a period not to exceed 1 year. So there's a maximum. If the court finds that the commissioner is not currently able to provide appropriate care in the designated program. So if there's not a designated program available right then, they've got a year to find it. But that year isn't without continued review. You look at lines 6 through 11, court reviews that order every 90 days. So in other words, if the commissioners come in and said, we don't have a program, it's not like you then don't look at it again for a year. You look at it every 90 days to see if there's a program has become available. That's the idea. And then you'll see Romanettes 2 and 3, page 9, the court finds that review that appropriate care can be provided, then it vacates the order of continued treatment and sends the person there. On the other hand, Romanet 3, court finds that habilitation still can't be provided, well, then they order continued treatment at the forensic facility. Again, this has a 1-year maximum on it. And then lastly, page 10, just because it's related to the subdivision E, lines 1 through 5, at any time, the commissioner can come in and say, look, we've got a program available, so you can send the person. They don't have to wait for, say they're at day 70, they don't have to wait till day 90 when the next review comes up.
So Eric, I know this is just linked to the Dale part.
Yes.
It wouldn't apply to the forensic facility part, like we don't have the forensic facility yet, so we're holding them in corrections.
Right, that's right.
So yes, it would apply to the forensic.
This language here? No, this
Okay.
is just specifically the Dale, as you said, the Dale subset of people.
And if the medical director is a new position and not on board yet,
They haven't filled it, you mean?
right?
Right.
Like, is there anything precluding who is doing it if there isn't a medical director yet? It could be the commissioner of DOC, or somebody else.
Well, the only reason I would say no to DOC specifically, again, is the draft in flux, but
Right.
there is language currently saying they can't do that.
But if that language went away, it could be anybody that's like,
Within AHS, I think, with anybody, because it's under their general authority. Yes.
so not somebody who is licensed in, like if we had some language about it has to be a licensed psychiatrist, or it has to be a, you know, PhD psychologist with, short of us adding anything, it could be Claire.
Well, AHS would be able to determine the person.
I mean, it could be, yeah, okay,
Yeah.
thanks.
But I think not right away because just because of the effective dates,
Right,
you know. But yes, and I still agree with you that there is that broad discretion as currently.
Right, Ian.
What happens after the 1 year if there still isn't a program available?
Doesn't provide for that. So.
Probably contemplate that.
Say, what was that again?
My question is just what happens after the 1 year period if after that 1 year there still is not a program available?
Then we haven't done our job.
Well, my one thought on this is like it's not about a bed somewhere. It's more about the type of programming that is necessary that like Vermont doesn't provide. And so in the 1 year, they don't get there.
Right.
What? I guess that means we're not doing our job. You're right, Kenny.
I just skipped 2 players, that's all. One for 3.
I mean, yeah, so there may need to be some language in there.
They just get released into the community.
Right, well, I mean, what happens right now?
No matter what, we're gonna have to tweak this as it goes,
Yeah,
right?
I mean,
But this
Yeah.
is specifically about Dale specific programs, not in the forensic program or facility,
so this is, yeah, one of the places where we need probably a little more testimony from Dale.
Yeah,
That,
I feel like if you're gonna set up, there's a determined window. You have to be clear about what happens when that window closes.
yeah. That makes sense, but I think that this is kind of the way it is right now.
Right, but we're trying to move away from that.
That's true.
Is right now working.
Yeah.
So we should look, double check and look at the, continuing the language under Act 248 for the continued treatment, the order of continued treatment. Maybe that's what we need to kind of contemplate a little bit more. But anyway, okay, so go ahead, we'll look.
Yes.
It seems like most of the rest are kind of just
Very technical.
technical, except
exactly.
for the page 13. Make sure that everybody notes that we did change that shall to may. So. All right, I think.
And corrected the cross-reference on line 13.
Yes.
Representative Goodland
I
spotted.
think, yeah.
What's that? Oh, my.
Yeah.
Oh.
And I should also mention on line 11, sorry, page 11, line 3, the if to of that Representative Arsenault spotted, so everybody's editorial oversight.
Important work here. It's Judiciary. So any reflection on where or what you gathered from corrections and institutions? Did they ask for any additional changes?
There was a thought that because actually, as it happens, it wasn't just corrections and institutions, because the chair of the Human Services Committee
Oh,
was
okay.
also at the table.
All right.
In corrections?
Correct. I mean, yes.
I should have gone here.
Yes, a correction.
Yes. So it was a concept that she was wondering about the clear and convincing evidence not so much the standard from a legal perspective, but as, in general, the clear and convincing evidence is used repeatedly as to describe the state's attorney's burden to show that a person is a substantial risk of bodily injury to another person. It's a dangerous evidence, right? And she was asking about, well, what if a person would be dangerous without, say, some medication or without some treatment of some kind, that absent that treatment, they might be dangerous, but otherwise they're not. And I said, I think that probably when a court's making that finding, it could take into account any relevant factors. And if that was a relevant factor, court could look at that and say, well, maybe in a particular case, a person's not dangerous because they're being appropriately treated. But her thought was, well, can we add specific language so that it would provide that when the court's making that clear and convincing evidence finding of harm that or that could take that sort of thing into account. So, point of discussion, just throwing it out there. You asked whether that was one thing that was discussed that was being pondered. No. I responded. That's more in the Judiciary Committee's jurisdiction, but I'll note that, and then you guys could continue to talk.
So we already kind of have that if somebody is ordered to be released, because the monitoring specifically is to make sure that they're continuing that treatment.
Yes.
That presumably is one of the rationales for why they're not dangerous. If we need to be more specific about that, and are we being more
He
specific?
looked at that language and said, why can't we have that everywhere else?
Appropriately treated, so somebody, whatever the reason, they're released and without medication, they're considered to be dangerous. With medication, they're considered to be not a public safety risk, I guess. And so how is somebody monitored as far as that they're going to continue to take their medication if they're released?
That's what we have in here, I think.
Yeah, you're right, that there would have to be some kind of oversight, and there is language on, just as an example, it's in both places, but page 6.
These people, but not for.
Say, let's say the person's released.
Yeah.
Page 6, lines 11 and 12. The order can be that they have to go do a prescribed regimen of medical, psychiatric, psychological care treatment. So that could include medication, for example. But you're right. Then the question becomes, well, who's keeping an eye on that?
Right.
That's the appropriate supervising department. So it could be mental health, could be jail, could be health. But yeah, it is going to be their responsibility to make sure that happens.
Is there anything that's written or any language that says how they do that?
Look on page 11, I think is where that is. G, subsection G, I think gets at that. Monitoring compliance with orders issued pursuant to subdivision C5, which was way back what we just looked at.
I guess where I'm going with it is somebody there to watch them take the medication every day. That's what you would need, somebody there every day to document that somebody is taking their medication, especially somebody who's going to be public safety hazard and dangerous without it.
Do that.
Yeah, and I mean, that is what the monitoring is. And if you look at the G1B, it's like if the person's continued release creates a substantial risk of bodily injury, they're to be recommitted. And that's what this section is aimed at, which is trying to get at it, I believe, in part. Yeah, Ian.
I think can we talk on this a little, the general putting in medication language wherever there's a clear and convincing evidence sort of standard? Is that, in my understanding, that's kind of what?
Not medication specifically, but it was more about some sort of treatment that was keeping them not dangerous.
So if looking on page 5, line 10, it says I think this is kind of where I'm seeing is like one of the big, okay, it's the, if state's attorney is able to demonstrate by clear and convincing evidence, and then it's establishing that the person has a qualifying condition that would create a substantial risk of bodily injury to another person. So like that's what they're trying to prove. So it's going to be like the totality of the evidence of all sorts of things probably brought in. And I think it would be very odd to sort of prescribe in any way really like what that hearing looks like or what is considered.
Yeah, I mean, I think the attorney for the defendant
Should bring up the-
should be saying, they're fine with the treatment and that should just be part of the order of release, you know, that the order of release should have continued treatment. It would be argued, I don't think we can discuss that.
And I could see like if the underlying crime that was committed, the person was off their medication, then that could be evidence the state puts on to show that they are at risk. And, you know, it's like, I think probably going to be part of where the line of litigation is on like whether they're at risk or not. If they have the qualifying conditions, the risk of harm there, and whether they take their medication or not, it's probably just a question of fact for the judge.
Right, whether there can be, yeah, Ken.
Is that already statute or in law, or we're following that protocol or whatever I'm trying to look for, counselor here with stuff? I mean, it's being monitored. We're already doing that. Like, and I'm not picking on him for a change, but why are we trying to nitpick this so much? It's already being done. Am I wrong?
Well, I think the bill proposes, as I was suggesting earlier, that using the language that Representative Goodman was pointing to, for example.
Well, I don't like that already.
Well, I pointed to it first.
That's true.
That it does encompass those types of judgments. That, you know, the court deciding whether or not the person's release would create a substantial risk of bodily injury, whether or not there's treatment that would keep them from being a danger would be relevant. So it's kind of on, like I said, the defendant's. Now, that's not to say that you couldn't also say it, but and the same thing I said in the committee, I think would already be part of the court's decision. As you say, that's the kind of thing they'd be doing anyway. So one of those, really, whether you guys want to throw that language in there is to something that we think that the court's going to be doing anyway.
So the court would be doing that part.
Yeah.
Automatically, it's going to fall down or go over to the other people to take care of the individual, right? To try to get them well, or their help or civility or whatever, right? I mean, the process is already in place.
In the bill, you mean?
Well, in the bill and what we're already doing.
Right.
I mean, this whole thing, I mean, I'm going to keep going back to the whole thing. It seems like where everybody is hung up in this, maybe not so much in this room, I'll give a little bit of, is the other room, is the other committee. And I'm not trying to give them a hard time. It's just, I get it. But it's like doing nothing is the worst possible thing. And we want to get it right as much as possible. It's not going to be perfect. Nothing is perfect. And we tweak it along the way. But when we're trying to when we're trying to micromanage the committees, the professionals already in place, mental health, all that stuff, let them do their job. And then as it comes back, if it needs to be adjusted or whatever, we do it. The future legislators that are in the bill, hopefully they follow through on that, because this is a major component of public safety to the outside world, and also the person that, we need to find out where they are mentally, whether they're compatible to stand trial or not. Am I misreading this?
No, I don't think so. I think you got it. Page 7. Person, what's he got? Supervised,
Could you just say that one more time? It's taken me 8 years to hear that. I want to enjoy the moment.
I couldn't have said it better myself.
Wow.
Yeah, what'd he say?
I mean, Eric, you just need to be nonpartisan. You don't have to like go overboard.
Sometimes the situation kind of warrants it.
Okay. Yes.
I don't know what to do with myself.
Tough act to follow right there. Not that I know, but I'm pretty sure that there's been people that have gone through the court system that have been part of their, I'll call it aftercare. They've probably been ordered to take medication if they're gonna be released. And I guess I would like to know, maybe hear from somebody. I don't know if we don't even know if we have time, just to see how that works, how somebody is monitored. But I realize there's some language in here, but it doesn't get specific on what type or who in the mental health world, I guess, would be monitoring these people to guarantee they take their medicine every day, just because they're ordered. And you know, if somebody has oversight over it, that doesn't show me the person that's doing the actual work and how that works. Because if we're dealing with the most dangerous people out there, you know? I'm not saying they're bad people, there's mental health issues here, that some heinous crimes that have been committed. And I just need a little more detail on the process as far as how they're monitored, other than that they're going to be.
Let us remember that victims, people with mental health issues are more often victims, just saying it for the
That's,
record.
Barbara, that's got nothing to do with
It
this.
doesn't, but I'm saying
It's
it
got
for the record.
nothing to do with
because
what
it-
I'm saying.
So we need to be sure
They
that,
need to be monitored.
Yep, I'm just saying, I don't want,
What about the victims that they have caused?
absolutely. I'm not
Well,
disagreeing
let's
with you.
not get off track here and get into the weeds.
so, yeah, as far as the monitoring, I think part of it though is, part of what, it was either the rulemaking under the Senate version, it's in the feasibility plan, under what, Corrections and Institutions has brought out, where they specifically talk about how the monitoring will happen. So we're gonna have another stop to, to understand exactly either be it rulemaking or this feasibility plan, that this is more of the details of the process.
Okay, to be determined.
Yeah, so,
Okay.
and, we're gonna get a chance to be looking at all this again. Assuming this thing passes out, we even have a facility, a feasibility plan or rulemaking, so thank you. Yeah. Any other questions for Eric? Because otherwise I think we'll adjourn until tomorrow. I don't think we'll be meeting after the Florida game. Suppose we're gonna go till 5:30. That was the prediction. So tomorrow I do have miscellaneous bills scheduled just to kind of get a initial idea of what's going to be in there. And probably some more testimony or discussion on this. Maybe what we
Let's
do
just
need
throw
to-
the forensic facility into the miscellaneous bill.
There we go.
And you're controversial.
Is to vote.
Would you like to vote this?
Seems unlikely that we're gonna get voted tomorrow, but that seems unlikely. Depends. It depends on where Corrections and Institutions is, and if we are keeping the option that DOC is part of this feasibility plan, in my view, and not explicitly excluding them. And we need to work a couple other things here. We'll probably try to get Dr. Bowen or somebody from Dale tomorrow to address that one issue regarding the 1 year, what happens after the 1 year.
Yeah.
Yeah, on page 9. So I will reach out. So we'll adjourn until tomorrow at 9. Give us all a couple hours.